You know that expression, don't poke the bear? Yeah, Judge Stephen Everett is the bear, and Donna's poking. She's like, you know what? I'm going to blame you for my conviction.
At this point, I do need a decision. Mrs. Adelson, please rise.
And the jurors. It was unfair, and you could just imagine her stomping her feet like she did when they read the verdict. Do you remember that? Oh my word, she threw a whole tantrum. Okay, and glaring at the jury, at the judge, and just blaming everyone but herself for the position that she now finds herself in. Now, disclaimer, if she is granted a new trial, because that's what she's asking for and that's what we're going to go through today, all her reasons why, we'll watch that trial together. Let me know in the comments below if you think she'll be granted a new trial or not. But first, let's listen to everything that her and her defense team have got to say. Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Her trial started with jury selection on August 19th of 2025. Opening statements took place on August 22nd of 2025, and by September 4th of 2025, she was found guilty on all counts, which was first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, which was for her role in the murder of Dan Markel. And while there's a lot of circumstantial evidence, which is still evidence and it all adds up, damn, some of the most compelling evidence would be my top three are, number one, she hand wrote and signed the checks, sequential checks, 44 of them, to Catherine McBanawa, who was the intermediary between the Adelsons and the hitman. Yeah, okay, Donna, you did that. Number two, the wiretap calls from that FBI undercover sting operation from the bump. That when she said to Charlie, this TV is going to cost about $5, and like, hey, this involves you and me, the two of us. That, okay, that was hectic. And number three would be when she tried to escape the country with a one-way ticket to Vietnam after Googling non-extradition countries.
Your cell phone? No, I don't want to give it to you. Why do I have to?
Because my attorney said not to.
Why do I have to give it to you?
So those are my top three. What are your top three pieces of evidence that they had against her that led to that conviction? Do you agree with the conviction or not? Do you think the jury got it right or no? If you missed any of the trial days, they're all there for you. The replays are there. They are timestamped, so you can look at the pinned comment, the description box, or just hover over any of those replays just to find the exact witness and moments that you want to see. Like when she had pretended to be hard of hearing, she said she had tiny ear canals, okay? And she can't hear properly, but she sure heard the verdict properly. That moment, she didn't need any earphones. Here it was obviously turned inside out. Look at Donna. Donna, your headphones, they're the wrong way around, lady. Can't hear a damn thing like that, especially this side. The other side looks okay. What's going on with this ear here? Okay. Flip that over. Judge, please. So I'm going to put Oma in the corner here. Oma is a word, it's grandma in Afrikaans. Okay, Oma's going over there so we can see who we're referring to as I read you the defendant's motion for a new trial and for leave to interview the jurors. Okay, so thank you to Grizzly Cat for sending this document to me. If you want to buy her a coffee, the link is in the description box below, as well as my coffee link and the Mod Squad coffee link. There's 3 separate coffee links. Make sure you pick the one that you want to use today to buy whoever a coffee, and just know that every one of us appreciates that support. Defendant Donna Sue Adelson, by and through the undersigned counsel, pursuant to Florida Rules of Criminal Procedure with all those codes, respectfully request. Really? Are you sure it's respectfully? Okay, sorry. Request that this court grant a new trial, and in support thereof states as follows. 1. A jury convicted Mrs. Adelson as charged in the indictment on September 4th of 2025. 2. This motion is timely filed within 10 days of the rendition of the verdict pursuant to Rules those codes. 3. Mrs. Adelson requests leave to interview juror number 5 and juror number 7. Why? Why number 5 and 7? Oh, you're picking on those two because they did interviews with YouTubers. And the things they said, you just want to nitpick that because that's all you got, Donna. That's all you got. Okay, so one of them was the 4-person. Number 4, Mrs. Adelson files this motion for a new trial on the following grounds. 1. Juror misconduct. 2. The verdict is contrary to the law or the weight of the evidence. So that's when you're already starting to poke the bear. I don't think Judge Everett's going to like that. 3. The court erred in a decision of any matter of law which arose during the trial. We saw it with our own eyes. Okay, anyway. And 4, for other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Really? It looked like the most fair and impartial trial to me, with the most fair and cool and calm judge almost ever. Judge Everett is amazing. And Donna is the 5th person convicted in this case. So again, Donna, you're not that special. You're just not.
All my bags are where?
They're right in the back. Right there where you saw me open up and put your check. All
okay.
over right there.
Oh, okay. Thank you.
In my opinion, based on what I've read that I'm about to read to you, I don't think she's going to get a new trial, but let's see. Also, for someone who wants to, I'm sure there's going to be 1 or 2 comments that want to be like, Grizzly, this is her legal right. Why would you say that she's demanding a new trial? Why would you say she's stomping her little crocs, her feet in a little jail crocs? Why would you speak like that? This is her legal right. I know. And it is my right to snark at it. Okay, because I think she's extremely entitled and she's always gotten her way and she just can't believe this outcome. 75 years old, this is not how she imagined her retirement going. Okay, but again, she's in a gated community with 24/7 security, so you'll be all right, Donna. Motion for leave to interview jurors. In the court's preliminary instructions to the jury, the standard instruction was read. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication such as emailing, text messaging, posting information. Oh my, they put that in italics so that they could draw attention to this. You may not post about the case would be the operative words, but they're ignoring that there. Okay, or a website or any other form of communication. Let's quickly look at this footnote. It says, although the jurors have identified themselves through social media or media appearance, the court previously ordered the parties to refer to the jurors by their juror numbers. Yeah, okay, so this, right, let's get to the next point. Subsequent to the trial, juror number 7 went viral on TikTok. Viral? Is this Jackie Fulford writing this? Who literally said, do you remember this thing called Skype? And she said that she's not tech savvy and doesn't know much about social media or technology. But here she's like, you know what? That 4-person went viral on TikTok concerning her jury service.
You guys are way younger than me, so maybe you don't even know about this, but I guess there was a thing called Skype. I don't even know if it still exists, but I guess it's like FaceTiming, but doing it on your computer. And that's how he wanted to talk to his kids.
She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26th of 2025. A flash drive with this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by the juror from her account. It was not. It's... Wait, let me show you. I will show you quickly here. Was the 4-person, right? Her name is JC. She's done multiple interviews on YouTube, on multiple channels, and she has also made these TikToks. And here she talked about her postings. Okay, so let's quickly watch this and then I'm going to show you that she hasn't deleted what they're just referencing now. Look at this.
Foremost. Number 2, as far as people's concerns as to me being on social media and posting my TikToks in the last week or 2, there was no rule stating that we cannot be on social media. The rule is provided by Judge Everett in this case, okay? We cannot seek out information about this case. We cannot talk about the case with anyone. We cannot listen to others talk about the case. We cannot do anything in regard to the case during the trial. But now that I'm released as a juror, I have the freedom to say and do whatever. But also in that regard, I don't watch the news. It's depressing. I haven't watched the news in years. If anything, I'll check my weather app, my little Apple weather app once a week, just to see. My For You page on my TikTok, where I am the most active, is mostly like TikTok shop videos, like members of like the moms of TikTok community, because that is the content that I typically engage and interact with. I also post that type of content sometimes, just like trendy, funny, like music videos, whatever else like that. Basically like stupid humor and then mom stuff. That's what I look for on social media. So I'm not breaking any rules. Along with that, I have time before court, during our 1 hour, at least minimum, lunch break during the days of the trial, and then after court to do as I will in regard to all of that. So no rules were broken, no rules are being broken now. I appreciate all of your guys' concern. I'm also going to prove that I was on the jury, because there's some of you who just doubt it.
Okay, so there she proved that she was on the jury. Now, if we just go to her page here and we scroll down, the one that they're referring to her deleting is actually right over here. This one. Okay, so let me turn the sound off here quickly. It says, when I told God I needed a break, and he makes it so excuse me, we're trying to read there. To serve on a jury for a 2-week trial. She didn't say which trial. She did not talk about the case. I agree that she did not break any rules. Do you agree? So that was from August 26th of 2025. And yet in this document, that is what Donna and her defense are saying. She deleted that video. No, she didn't. Okay? No, she didn't. It's right there. Okay, I just showed it to you. So moving on. Here is where it says it. By the way, it's on page 2 of 18. They were informed by who? Who informed you? Says the undersigned seeks to interview juror number 7 concerning her social media activity during the trial. Shame. If that's actually going to happen, I feel sorry for the 4-person juror number 7, because she's going to need to explain to Jackie Fulford and Donna, right, about the algorithm, especially on TikTok, and that she didn't come across anything related to the trial, how that would be possible, what she was on there for, how long she was on there for, all of that. Okay. It says, additionally, juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Mrs. Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external rather than that which inheres the verdict. As a result, the undersigned seeks to interview juror number 7 concerning do you mean juror number 5? Because you just wrote, this is the 4-person, juror number 7. Keep up with your own document, okay, defense? The undersigned seeks to interview juror number 7 concerning his consideration of Mrs. Adelson's reactions to the evidence. We saw the reaction to the verdict. We also saw throughout the trial, Judge Everett reminding Donna to use her amplifiers if she needed them, because she forgot here and there that she was hard of hearing, And we also saw the judge multiple times tell Donna to not have those emotional reactions, not to look at the jury, not to try to manipulate, all that type of stuff. And yet she still did it. She still nodded her head. She also shook her head. She also glared at the jury. She made faces at all sorts of things throughout the trial. So anyway, juror misconduct, point number 1. They're going to more for each, right? Discussion of law. According to the Florida Supreme Court, potentially harmful juror misconduct is presumptively prejudicial, and then they cite other cases. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced this case. Then they cite other cases. Rather, it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Once improper contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial, unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. If juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. And if she gets a new trial, do you think the outcome would be different? Donna, you think 12 other people, do you think the outcome will be different? I mean, you never know. But I think based on all the evidence that the state presented, the outcome is going to be the same. Maybe they'll even deliberate quicker. Okay, so they took 3 hours and 15 minutes in this case. Just 15 minutes longer than the jury took for Charlie Adelson, her son. Okay, she's yet to be sentenced, by the way. She's got a case management hearing on October 14th of 2025, and then the sentencing date still is to be set. But of course, now there's all of this first. They got to deal with if Donna's going to be granted a brand new trial or not. Or is she going to be sentenced and go into the big house? Okay, checking in to her new gated community. 2, the verdict is contrary to the law or the weight of the evidence. Discussion of law. The only avenue for judicial review of the weight of the evidence is by motion for a new trial at the trial court level. In Robinson, the court stated, so they're citing other cases, which of course they always do. Just remember, I'm not a lawyer. If you're new here, hi, my name is Grizzly. Should have said that earlier. I'm South African. I live in Switzerland. I love documents, body cam, all these FOIA requests, press conferences, deep dives, bullet points, all of that, okay? Trials, watching live trials with you. Love it, all right? Court hearings, but I'm not a lawyer. So when I say they're citing other cases, I know that that's normal. I'm just saying I'm not going to read that. We're going to go to the main points of what she's complaining about. Okay, so a motion for a new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act in effect as an additional juror. This standard is different than the one used by a court in ruling on a motion for a judgment of acquittal, which was denied, I think twice during the trial, but it was denied, which utilizes a sufficiency of the evidence standard. Florida courts have held multiple times that when considering a motion for a new trial under this rule, based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. The trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. When determining the weight of the evidence, in essence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge. It's the same sentence, right? But the weight of the evidence does not appear to support the jury verdict. The role of trial judge in passing on motion for a new trial on the ground that jury verdict is contrary to the weight of the evidence is to weigh all of the evidence and determine credibility of witnesses so as to act in effect as additional juror. Now they're going to go every count that she was convicted on, okay? We're on page 5 of 18, so just buckle up. If you love documents like me, if you're a nerd like me, oh, we're in for a ride, yeah, because Donna has got lots of complaints. Count 1, first-degree murder. At this stage, the court must make a finding that Patricia Bird, that's a jail snitch, one of Donna's, friendies in jail that turned on her and testified against her at the trial instead of for her in the way that Donna wanted her to. Okay, so they say Patricia Bird was credible. So, wait. The court must make a finding that Patricia Bird was credible before considering Mrs. Adelson's alleged confession to Bird. Under no set of circumstances can Bird be considered credible. She testified the defense investigator with whom she spoke was a white woman. Miss Khan is obviously not white. She further testified that she told both Mr. Barnes and Miss Khan that Mrs. Adelson confessed that Mrs. Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Barnes and Miss Khan disputed those claims. Additionally, Miss Khan testified she never met with Mrs. Adelson. Thus, unless the court were to believe the defense counsel conveyed to Miss Khan that Miss Bird was to be offered money for false testimony, Miss Bird's testimony should be disregarded completely. I would like to grant that motion. Okay, we could disregard it. There's still a ton of evidence against you and you're still convicted, okay? If you want to go and rewatch Patricia Bird's testimony, it's all time-stamped for you. Just find the days, just go through each day if you want to, right on the playlist, and just look at the pinned comment and you'll see you'll see, normally they're on the thumbnail as well, most of the important witnesses. I can't put them all on, otherwise it'll just be thumbnails full of people. You'll be so confused. But just go to the pinned comment. That's a way to efficiently find the testimony and see what they said. You just read the little numbers and you click on when it says Patricia Bird, which was a later day. I think it was like day 6 or so, something like that. So it says, the same is true of Drina Bernard. Oh, shame, Donna, your jail daughter turned on you too. Now this one was interesting because they proved that there was a script that Donna wrote that was her handwriting, where she was trying to tell Drina what to say on the stand so that she could testify for her. But instead she testified against her. So Miss Bernard's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison release reoffender, Bernard's credibility was significantly impeached. The only one who testified this was Mrs. Adelson's words rather than Miss Bernard was Miss Bernard. However, the surveillance video admitted into evidence, that was some boring stuff to watch, but it was pretty cool to see Donna in jail. It was like a jail cam. And we were all wondering, what kind of defense would show the jury? See, that's our client in jail already. Look at her, operating in jail. Okay.
And do they walk towards the foreground of the video?
At one point.
Put that image in their mind, all right. Anyway, so however, the surveillance video admitted into evidence establishes that she and Mrs. Adelson worked together to write the script. No, it did not establish that. They could have been writing anything. They could have been writing down a commissary list on that day. Go watch it and then come back and let me know. Do you think it established that that's the day they were writing the script? I don't think so. Okay, so the theory of the state's case was that the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine McBonowa, Sigfredo Garcia, and Luis Rivera, and that she paid for the crime to be carried out. There's no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed, and for that reason the evidence is not sufficient to support her conviction as a principal to first-degree murder. I think under Florida law it is, especially based on everything they showed. Additionally, there's no evidence other the adoptive admission from Charlie Adelson's trial testimony that Mrs. Adelson was aware of her son's plans until September 17th of 2014. Dan Markel was killed on July 18th of 2014. So July, August, September, they're saying 2 months later is the first time that Donna knew about it. Oh, when she started writing the checks, which makes her just a sweet, sweet, innocent, helpful granny. Now, although a person can be convicted as a principal to a criminal offense based on words alone, there must be competent, substantial evidence these words were spoken in advance of the crime. A person can be convicted as principal to a crime under the section of Florida statutes, there's a number there if you're just listening, only if there's evidence that he or she committed some act or uttered some words to assist another in the commission of the crime when the crime was being carried out. The elements of the crime are set out in the leading case of Staten versus State, and there they cite another case, right? It says in order to be guilty as a principal for a crime physically committed by one must intend that the crime be committed and do some act to assist the other person in actually committing the crime. You mean like moving money around, getting Wendy a property, booking the TV repair guy to be Wendy's alibi on that day, the call logs, the writing of the checks eventually, changing the boys' names to the Adelsons. I don't, these are all just off the top of my head. So, it says, as acknowledged previously, intent is an operation of the mind and may be established by circumstantial evidence. Yeah. There certainly is no direct evidence that Mrs. Adelson intended for Mr. Markel to be killed. However, there also is no circumstantial evidence that Mrs. Adelson wanted Mr. Markel to be killed. I beg to differ. Let me know what you think. Even if there was, there is no evidence to establish the second element, that she did some act to assist the other person in actually committing the crime. McBonowa testified that per Charlie Adelson, his parents had stopped by his residence. Oh my word, how could I forget that? That should have been in my top 3. Donna going to Charlie's house to drop off the money the day that Dan Markel was shot. Remember the washed and the stapled money? Okay. So, McBunower testified that per Charlie Adelson, his parents had stopped by his residence on July 18th of 2014 after Mr. Markel was murdered. However, McBunower did not testify that Mrs. Adelson or her husband dropped off any money that night. Oh, it just magically appeared. And the state's expert agreed the state could not place Mrs. Adelson's or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18th of 2014. Okay, but the state's expert also showed how Donna literally put herself there by texting Charlie Adelson saying, "I'm outside your house." Okay. Even if Mrs. Adelson and Dr. Harvey Adelson did stop at his residence, it would have been approximately 9 hours after Mr. Markel was shot. To that, I'd say only 9 hours. Charlie was busy that day, okay? He was even late for his mother, who's like, "I'm outside your house." And then eventually he replies, "Oh, okay, I'll be there." And he took like half an hour to get there. So they were just waiting there, apparently, to drop off the money. Okay, so in fact, at the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid McBunower from his own money, which he kept stapled as confirmed by McBunower, Ryan Fitzpatrick, and June Umchinda. Charlie's testimony also included the fact that he did not tell Mrs. Adelson that he paid McBunower for the shooting until September 17th of 2014. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th of 2014. The defendant in Staten drove to the perpetrators to the scene of the crime, waited across the street, so this is citing another case, okay, while they were committing the crime, and then drove them away in the car. In these circumstances, the jury could legitimately infer that the petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a principal. Affirmative acts such as these are common in prosecutions under the principal statute. Judge Brad Thomas explained the rule as follows. To sustain his conviction as a principal, the state was required to establish that appellant intended the crime to be committed and do some act to assist the other person in actually committing the crime. Okay, but the call pattern on that day was there as well, where it's Donna calling Charlie, Charlie calling Catherine McBunower calling Sigfredo, Sigfredo calling Catherine McBunower calling Charlie, and Charlie calling Donna. Okay, so Judge Thomas noted that he was emphasizing the phrase "do some act" in the quotation from Staten to explain why the court was reversing the defendant's conviction. Although there was evidence that the defendant intended to participate in the crime, there was no sufficient evidence that he did some act to assist in the commission of the crime. In this case, as in Ammons, there is no evidence that the defendant did some act to assist in the commission of the crime. The most that the evidence shows is that she knew of the plan at some point. This is not sufficient under the rule of Staten and Ammons. Additionally, in Williams, the court held that even taking a broader view of the murder of Mike, the scheme that preceded his death whereby Denise was to make sure that Mike went on a trip with Brian, there was no evidence regarding what she did rather than what she was supposed to do. In furtherance of the scheme that day, as we have explained, proof of the conspiracy alone is not enough. Agreeing with someone to commit a crime or developing a criminal scheme with someone else by itself does not establish that the person assisted in the eventual actual commission of the underlying offense. At a minimum, there must be proof of some overt act or some words uttered in furtherance of the scheme that led to the murder. The state offered no such evidence at trial. Now, well, the bump was interesting, and Donna saying it involves the two of us. You and me, Charlie. This TV's going to cost about $5. Williams continued. There still needed to be evidence of what she did to assist Brian. Again, this is citing another case. As the offense unfolded, there was no testimony that Denise assisted Brian at the lake as the murder happened, nor any testimony that Denise was on the phone with Brian while he was at the lake with Mike, goading or encouraging him to go through with it or giving him advice or guidance on how to pull the murder off when things were not going as they originally had planned. In fact, there was no testimony about anything Denise did, any acts or words uttered to facilitate the offense, to encourage the offense, or to direct the offense at any point during that fateful day. To establish a criminal conspiracy, an agreement, and intent that the underlying crime occur are all that must be proved. Not so when proving principal criminal liability. The legislature eliminated the requirement that there be proof of a defendant's presence at the scene of the crime, and it did not eliminate the text requirement that there be proof of what the defendant did or said in connection with the unfolding of the crime that helped in its success. It is this proof that was missing from the state's case. Even when there is a scheme that precedes the murder, the crime is complete upon the victim's death. Unlike with a robbery, where the crime continues through the escape, evading detection of the murder after the killing would not be part of the crime. Okay. Then it said, the state may argue that Mrs. Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there's no evidence of what Mrs. Adelson agreed to pay the killers prior to the murder. In fact, McBunowa testified during the trial that the amount of payment was never addressed prior to the murder. Okay, well, Jeff Lacasse said that Wendy told him that her brother had looked into hiring a hitman and it would cost $15,000. Now, for this bunch, it was like $138,000, which was for Catherine McBunowa, Sigfredo Garcia, and Luis Rivera, if I understood that amount correctly. And then she also got a breast augmentation and dental work at the Adelson Institute, and she also got Harvey's Lexus. So, anyway, so moving on. The state may also argue that Mrs. Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to McBunowa, who then gave it to Garcia or Rivera. However, there's no evidence the tag number was ever given to Charlie, let alone McBunowa, Garcia, or Rivera. So you think they just had it out of nowhere? They just knew exactly which car to follow that day on their second run at, executing this hit. They had one practice run, a dry run, an intended day before, and then on July 18th of 2014, they followed Dan Markel around. When he dropped off his kids at preschool, he went to the gym, and when he got home, they pulled in behind him as he was in his garage, and then they shot him twice in the head. So, now, why do they mention this? Is because Donna Adelson, in her 2014 planner, had Dan Markel's car, make, model, and license plate number written down in it. Which is very weird because it was 2 years after the divorce, meaning Wendy and Dan's divorce, 2 years later, but the same year that Dan Markel was killed, Donna has Dan's license plate number written in her diary, in her planner. So I would speculate Wendy gave that to Donna, she wrote it down, Donna then gave it to Charlie, and Charlie had prepared, maybe Donna even prepared the envelope for all we know, Charlie had prepared an envelope to give to Catherine McBunowa, which was then passed on to Sigfredo Garcia, the trigger man, and then his bestie joined, Luis Rivera, the Latin King's gang leader, the getaway driver, right? And they had this envelope with all the information, a picture of Dan Markel, his car, his license plate number, and his schedule, where he would be that day, which Wendy knew, which is interesting, right? If you haven't yet watched my other videos in this series, which is Could There Be a Sixth Arrest? And the emails between Wendy and Donna, go check them out. They're on the playlist as well. There's a whole playlist for this case for you in the description box. But that's what that is about, just so you know. Okay, so it says, even if such evidence existed, there's no evidence that this was done on or even before July 18th of 2014. No evidence was admitted during trial to establish the purpose for which Mrs. Adelson had the tag number in her 2014 planner. Finally, with respect to the second principal instruction, there's no evidence Mrs. Adelson made any payment prior to the murder, or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Mrs. Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence as a principal to first-degree murder. Count 2. Conspiracy to commit first-degree murder. She was found guilty on that as well. The state's theory on count 2 was that Mrs. Adelson agreed with Charlie Adelson and others to kill Mr. Markel. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy the state proved as to Charlie Adelson, McBunowa, Rivera, and Garcia. The primary evidence against Mrs. Adelson was the motive that Mrs. Adelson desired to have her daughter and grandsons move to South Florida. Yeah, to win at all cost. Although there was certainly evidence Mrs. Adelson was not happy with the way that Mr. Markel treated her daughter in the litigation process, there was no evidence that Mrs. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of marriage had been settled. There was also no evidence Mrs. Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson looked into hiring a hitman in the summer of 2013. To establish a prima facie case of conspiracy, the state had to admit evidence that A, the intent of Donna Adelson was that the offense of first-degree murder would be committed, B, in order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson or Catherine McBonough or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. The undersigned asked the court to consider the evidence without the state's spin. The state's spin placed on it. How dare the state place their spin on this? Certainly, Mrs. Adelson suggested crazy and offensive methods. Yeah, okay, let's highlight this one. The defense says, certainly Mrs. Adelson, their client, suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. And what finally pissed Donna off, pushed her over the edge, when she was no longer allowed unsupervised visitation with the grandkids. Remember the grandma motion? Once the dissolution was final on July 31st of 2013, what evidence exists that Mrs. Adelson continued to have a motive for Mr. Markel to be out of the picture if we ignore the emails where she suggested her daughter ensure Mr. Markel be obligated to share expenses with her for their son's college education, etc. All events which would necessarily take place after he was killed. There is none. Okay, but if we ignore the emails, which we will not be ignoring the emails, those emails are important. Text messages are important. That was evidence. The jury considered it. Okay, where is the evidence Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. The bump and her response to it. The state's entire case is premised on speculation, impermissible stacking of inferences and theory. Without the speculation, theory, and impermissible stacking of inferences, there was no evidence Mrs. Adelson ever agreed for Mr. Markel to be killed. Okay, the evidence, okay, number 44, here we go. The evidence of flight was not that she was fleeing to avoid prosecution, but at that time, in November of 2023, she believed in her son's innocence, and that if he were convicted, the state would next turn their attention to her. Why? Why is that? If you're just a sweet, innocent granny who has nothing to do with this, why would you think they'd turn their attention to you? And then why would you specifically look up non-extradition countries, and get a one-way ticket when you could certainly afford a return ticket, and it is actually the cheaper option, by the way. Don't let anyone convince you that a November to January return flight would be worse than a one-way ticket. If you buy a one-way ticket and then another one-way ticket, that would be far more expensive. But here they claim, no, we were just it was actually cheaper. And I was just going there for, peace of mind. Yeah, but then it was also Charlie's plan before he got arrested. He's like, if I ever get any sign that I'm going to get arrested, I'm going to Vietnam. Why? Because he had timeshare there with a friend. So it became Donna's plan. I'm going to Vietnam. She shouldn't have even Googled non-extradition countries because Charlie had already done the legwork. She could have just gone on a flight and gone to Vietnam and checked herself into that timeshare. Instead, her and Charlie were checked into timeshare in the jail. He's now serving a life without parole sentence in prison, and he's housed in South Dakota because he's there for his own safety, apparently. And he did not testify at his mother's trial, unfortunately. That would have been interesting to see. Moving on, so she says, if he were convicted, the state would next turn their attention to her. That doesn't make any sense. Wouldn't it be to Wendy? Rather than consciousness of guilt. That is evidence of her real fear. The witch hunt would continue. Plausibly, the witch hunt would be Wendy next, Donna. Why you? Why you? Where you going? Okay, so the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Although the fancy Although the fancy presentations prepared by the state may have been persuasive to the jury, Mrs. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury's verdict is premised. How dare they have their fancy presentation? Now, what stops defense attorneys from having fancy presentations? Why do they rarely go that extra mile? They could do it too. You know, if YouTubers like me can do it, they can do it. Okay? Yeah, the jury didn't sound very impressed with their just a printed out picture of Donna and a printed out picture of Dan Markel, and then calling Dan Danny the whole time. Like, from the defense side, they were like, what is going on here? And they said the state did seem more organized. Count 3, solicitation to commit first-degree murder. The state's theory on count 3 was that Mrs. Adelson convinced her son Charlie to find someone to murder Mr. Markel. The charge of criminal solicitation requires evidence that the person intends for the crime to be committed and that she commands, encourages, hires, or requests another person to engage in specific conduct which would constitute the commission of the crime. As the jury instructions set out, the state must prove beyond a reasonable doubt that A. Donna Adelson solicited Charles Adelson or Catherine McBonower or other persons to commit first-degree murder, and B. During the solicitation, Donna Adelson commanded, encouraged, hired, may I add a word, coerced, okay, or requested that Charles Adelson or Catherine McBonower or other persons to engage in specific conduct which would constitute the commission of first-degree murder. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. You mean how she was trying to cast a spell on Wendy Adelson? How she was trying to convince her in those long emails how she should take control of her life and how she should make Dan Markel's life absolutely miserable. Yeah, we saw those emails. So rather than competent substantial evidence establishes that when Charlie was speaking with Miss McBonower concerning Mr. Markel, he would at times make or receive calls from Mrs. Adelson. Miss McBonower did not testify to any messages that Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. As with the argument concerning count 1 above, the evidence may have established her involvement after the fact, and her complaining to Charlie about how Mr. Markel treated Wendy Adelson. There was simply no evidence that she commanded, encouraged, hired, or requested Mr. Markel to be murdered prior to the murder. Common sense and the plain language of this Florida code require the solicitation to be committed prior to the crime. With there being no testimony from any witness or any evidence admitted that Mrs. Adelson asked anyone to murder Mr. Markel, the entire premise for her conviction on count 3 is simply speculation and, as argued in court, an improper stacking of inferences. For these reasons, Mrs. Adelson's conviction on count 3 should be set aside and a new trial granted. Number 3, it says here, the court erred in a decision of any matter of law which arose during the trial. That's poking the bear. The court erred in denying Mrs. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. They wanted us to look at all her chicken scratch to try to water down the fact that she had Dan Markel's car make model license plate written in her 2014 planner. Interesting. During trial, the defense sought to admit the complete planners to correct the misrepresentation expected to be made by the state, and which came to fruition during the state's closing argument. The state argued that Mr. Markel's tag number in the 2014 planner was evidence that Mrs. Adelson provided the tag number to the shooters, despite there being no evidence this happened. Rivera testified there were words on the photograph given to Garcia, but no evidence was offered as to what those words were. With the 2023 planner, the state argued that the planner indicated, in anticipation of fleeing the country, that Mrs. Adelson was selling personal items. Admission of the complete planner would have corrected the misrepresentation made by the state, as there were 39 other entries in the planner where Mrs. Adelson listed to sell the identical items as far back as January of 2023. Oh, you mean when her fear started of, oh crap, I'm so going to be arrested, because Charlie Adelson was already arrested in April of 2022. In Curtis versus State, the court recognized that judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. As the court admitted portions of both planners, there's no question concerning the authenticity of the materials. Exclusion of the planners infringed on Mrs. Adelson's right to present a defense, and the evidence was important to defeat the argument that she was fleeing to avoid prosecution. I think even if they tossed out that evidence, her being there after Googling non-extradition countries, the hot mic moment on the jail call that she had with the son where she thought she hung up because she couldn't hear him anymore, but yet she hadn't properly hung up the phone and it was still recording while she was talking to her friends in her living room, which so happened to be a lawyer and her husband and other people in the room, and she was saying, we have to get our affairs in order, we have to set up these trust funds for the grandkids. We have to get Wendy over here so I can give her passwords to the safe and to all these things because we're getting the hell out of here. She even talked about self-deletion, that her and Harvey were thinking of doing that together, but then they decided they're rather going to do this. All of that was extremely incriminating. So you know what? Yeah, toss out the planners. We don't care about Granny's little planner there. But is it not interesting, however, or put the whole planner in? Okay. Is it not interesting that she had Dan Markel's license plate number written in her 2014 planner when he was murdered, July 18th of 2014? It was somewhere, I think, at the back of the planner, so it wasn't like on a specific date. Now, it says for other cause, not due to Mrs. Adelson's fault, because, you know, she's faultless, okay? She did not receive a fair and impartial trial. Did you think that it looked unfair? This was unfair. I wanted to be much more theatrical. I want to use all the manipulation skills I have in my toolbox. How dare they prevent me from doing that is what I'm hearing. So we're on page 13 of 18, by the way. Okay, so it goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and United States constitutions. The Due Process Clause of the 14th Amendment guarantees the right of state criminal defendants to be tried by an impartial jury. The 14th Amendment incorporates the essence of the 6th Amendment right to be tried by a panel of impartial, indifferent jurors whose verdict must be based upon the evidence developed at the trial. As Chief Justice Warren has observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusion of factors into the trial process that tend to subvert its purpose. Specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all forms of trial conform to the requirements of law. The court explained in Shooters v. State that the presence of courtroom observers wearing uniforms, insignia, buttons, or other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute denial of the accused's right to a fair trial. Citing other cases again, there are situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. When such a claim is raised, a case-by-case approach is required to allow courts to consider the totality of the circumstances. A defendant claiming that she was denied a fair trial must show either actual or inherent prejudice. Actual prejudice requires some indication or articulation by a juror or jurors that they were conscious of some prejudicial effect. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. This is a case where the cumulative effects of a number of factors constitute inherent prejudice, resulting in Mrs. Adelson not receiving a fair trial. Yeah, okay, let's hear it. When the court would rule against the defendant, on many occasions, the members of the gallery supporting the state would laugh out loud. Okay, we apologize. The Grizzlies, we're sorry, right? We're sorry about that. Okay, sorry. Members of the gallery, okay, in the courtroom, not us. Counsel for the defendant brought this to the attention, brought this to the attention of the court, and the court appropriately advised the gallery that this was not acceptable. Don't laugh at the granny who's on trial, okay? Woo, okay. The court did this on more than one occasion. Oh my, okay. However, the conduct continued throughout the trial. I'm going to have to drink some water. Don't mind me. This undermined the credibility of the defense in the eyes of the jurors. How dare they mock us like that? We're trying to flirt with the witnesses. Yes. Not only were they laughing out loud. Videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. I did not see that, but okay. Did you see that? This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. Because the defense, you thought your closing arguments were good, eh?
We didn't put that evidence on. The state is the one that made it an issue. They put those documents into evidence, the things that Mr. Markel had filed.
Okay. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. Oh, please, we saw your fake ass, no tears, crying when they showed autopsy photos of the victim, Dan Markel.
Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as best possible, you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts.
Yeah, that as well.
The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well.
We saw it, Donna. We saw the head shaking, the nodding, the glaring at the jury, the downturned mouth. We saw a lot of emotion, even though that's why the judge had to repeatedly, on numerous occasions, admonish Donna Adelson, because she's very naughty.
Once again, Mrs. Adelson, I'm going to reiterate the instruction that I gave to you last Friday concerning any reactions that you may have to either the testimony or the evidence in the case. I understand this may be a distressing thing for your child to be offering testimony in your trial. However, you are to control your expressions and your emotions. Do you understand those? Everyone can take their break.
Okay. She doesn't like rules, okay? Only her rules. So, during the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings because she thought she's going to be acquitted. Okay. She also thought her son would be acquitted. So when her son, the night before the verdict was reached for him, he literally gave away all his commissary items, like to all his jail friendies, because he's like, I'm going to be free tomorrow. And his mom, Donna Adelson, packed him a baggie and booked him a hotel room, toothbrush and all. Don't worry, son, we're going to come get you. You're going to stay in a hotel. It's going to be lovely. And then he was found guilty on all counts. So she's like, I don't understand. You spoke so well on the stand, Charlie. I don't know what they were thinking. They were using their brains. Here again, she thought that she would be acquitted. So when it says the defendant did not do anything to disrupt the proceedings, she did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. Choked up? Did you see how she looked at Wendy? Did you see how she looked at Rob Adelson? Holy crap, okay. She did not speak out. She was not sobbing out loud. She was not crying out. She did need tissues to wipe away her, non-tears. I think you forgot the word non-tears. Okay, to wipe or dry tears. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to lack of emotion during the trial. This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. Oh, please. That was victim impact statements after the verdict, which the jury didn't even get to see. Okay? No. So the state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Mrs. Adelson decide whether she would testify. You literally said you do not have other witnesses. Okay, anyway, both counsel for Mrs. Adelson as well as Mrs. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during the trial in order to make and knowing an intelligent decision in what was probably the most important decision in her life. This was especially significant in that the state made numerous changes to evidence during the trial. How dare the state rip apart our defense, which was going to be that Donna was going to tell the exact same double extortion theory that her son had tried on his jury. How dare they already attack that before we even get to it? Now we can't even do 4 to 5 days of submitting our evidence because they've ruined it for us. They've already made sure that we have nothing to work with when it comes to those theories. Yes. So, okay, I have never, in any of the trials we've watched, seen anyone get more time and more opportunity to decide if they would testify or not.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not.
Decide
I cannot
now.
make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
At this time, I don't want to testify.
Very well.
It was atrocious. Oh my word, Donna being like, I don't know. I'm just not ready yet. Okay, another break, a longer lunch, an hour 15 lunch, another coffee break. You got 5 more minutes. One more round, bring up the witness, tell me afterwards, and still Donna could not decide because she thinks she's special. You're just another criminal defendant, Donna, and now you're convicted. By the way, if you have other alternate or agreeable, whatever, opinions about what I'm saying, please leave them in the comments below. Can't wait to read those. I also do like to make YouTube shorts responding to your comments these days, whether they're nice comments, snarky ones, trolling ones, whatever it is, questions, answers, things you point out. Love those. So leave comments below and let's see if I react to your comment. When the court recessed early on September 2nd of 2025 to allow counsel to meet with Mrs. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Mrs. Adelson. Counsel then drove to the detention center to meet with Mrs. Adelson for the 2 hours authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Mrs. Adelson's decision. Not only did the court force the defendant to make an uninformed decision, oh please, you were there. That's your job to inform your client. Okay, it's probably not a good idea, Donna. We know you want to be a control freak. You want to get up there. You want to tell your story. You want to try and manipulate everyone and coerce everyone. But no, Donna, it's not a good idea. Right? But they're like, she made an uninformed decision. He threatened to hold counsel for the defendant in contempt. How dare he? So it says not only did the court, being Judge Everett, force the defendant. I mean, wow. It came to that because she couldn't make a decision. But then it also says they were going to hold the defendant in contempt of court. Totally valid if you saw the moment, because they were continuing to speak to the client about this important decision that she had to make, which again brought an audible, derogatory response from the gallery. I want to know what that was. Oddly enough, whenever the state needed additional time to set up electronics for opening statements, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them additional time, he joked with the prosecutors about it. Or the defense is going to poke the bear now. Donna and her defense. Poke the bear. Judge Everett, the Grizzly. Who is a lighthouse, but could very well be a tank if he needed to be, right? That quote comes from Judge Don Ash from the Sean Finnegan trial. He taught us all to say, he said, be a lighthouse, not a tank. He lives by that quote in his career. And Judge Everett is most certainly a lighthouse, but do not cross him. Oh, he could be a tank. But I know, I'm sure he'll be very calm, cool, calm, and collected as he most likely denies this whole ass motion. But let's see. Thus, leaving the clear impression that he favored the state in this case. Judge Everett has favorites. We have sibling rivalry over here. How dare they with their fancy presentations? Surely the decision of a defendant facing life in prison is more important than the extra time that the state requested to conclude its closing argument. The state got like 7 minutes, okay, extra. Donna got hours extra just to make that decision, which she already knew she would make, and she indicated before the trial even started that she wants to testify. So her chickening out is what took so long to make, because she knew, I'm going to chicken out and this is not going to make me look good, but I don't know what to do because I don't want to be cross-examined by Georgia Kappelman. Okay, Donna is so exhausting. My word. Where's my coffee? I have to have it ready for when I'm done with this. We're on page 16. Okay, I'm going to top up with this coffee afterwards. Okay, so the defendant's request was not granted and made a huge impact on the outcome of the case. No, it didn't. If she got up there, it would have been a 1 hour deliberation versus 3 hours and 15, in my opinion. You're so guilty. I wish she had gotten up there. We so wanted to see that little granny act, with a little cardigan getting up there. I don't know. But imagine that cross-examination. That would have been so good. Okay, so the court showed favoritism. Please, these are such weak arguments. I hate arguments like this. The court showed favoritism to the state at most every juncture of the trial. While the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its tasks over lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. Guys, they weren't even able to get their nutrition on while scrambling to figure out how to defend this client. Come on. You could eat a protein bar while looking over the evidence or whatever it is you needed to do. I would know. Not that I've been in court or on a jury. I'm just saying I would know. Sometimes you gotta just like on these long trial days, you don't see me like munching away. I'm sitting there for 8 hours with you guys. You know what I mean? You can make a plan. You can intermittent fast. It's good for you. But anyway, shame. They didn't even get to consume their lunch. The court sustained the objections of the state without, it's like a huge pity party. I hate this vibe. Anyway, the court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Additionally, even when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury that the objection was overruled. During one sidebar discussion, the court asked the counsel a question. As counsel attempted to answer the question, counsel was met with a scolding not to talk over the court. How dare you scold us like that? Counsel thereafter was prevented from answering the court's questions. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on the part of the court, not only the defense but spectators in the gallery, the media, and those viewing the trial through the media. Is that me, huh? Okay. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed towards Mrs. Adelson and her counsel in this case. Okay. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe that he favored one outcome over the other, and that was read in this case, it is not realistic that a jury can set those feelings aside. I think they can. I think they're smart and mature enough to do so, but all right. The jury clearly disregarded the instructions of the court on other issues and did so on this instruction as well. Wow. Just throw the whole jury under the bus. The totality of circumstances present during Mrs. Adelson's trial established inherent prejudice. To wit, there was an unacceptable risk of impermissible factors coming into play. Wherefore, the defendant respectfully requests that this honorable court, okay, so after poking the bear, throwing the judge under the bus, the jurors under the bus, this honorable court grant this motion, grant Mrs. Adelson a new trial. Do they want to put in brackets, new attorneys? Please not us, don't pick us. Okay, and for such further relief as is just and proper. And there you have it. Those are Donna Adelson's complaints, and that is why she would like to have a new trial, because she just can't believe this outcome. This is not how it was supposed to go. She's supposed to get away with this, okay? And live a long and lavish life with Dr. Harvey Adelson in a beautiful apartment. She was supposed to have a wealthy retirement. She did not coerce everyone for this long and work this hard at manipulating the world to end up in freaking prison. No way. Okay, so let me know what you think in the comments below. Thank you so much for listening. If you made it to the end of the video, let me know as well. Remember to check if your like button works. Also, that helps to get this video into the algorithm so that other people can see it. Not everybody gets the notification. If you want more reliable notifications, you can go to patreon.com/grizzlytruecrime and join the free public tier. I think you just put your email address and a password. You sign up for free and you'll get 90% of the notifications. Why 90? What's the other 10%? Well, sometimes the other 10% would be behind the scenes content. Like I recently went to visit Lucerne here in Switzerland, and I went on a boat and I took some video clips and things, and I put that on Patreon as a behind the scenes video for the paying Patreon members, because man, I appreciate the support so much. So if you are a Grizzly patron, thank you so much. If you're a YouTube member, thank you as well. Thank you to everyone who supports the channel and the work that I do. And I will most certainly see you again very soon. Let me know if you want to see anything else. I will certainly update you on this. Make sure you check out my YouTube shorts, because a lot of you missed that. And that's where I'm updating you on small things like, let's say the outcome of this, denied. That's a one-liner. I can't make a video with the one-liner or go live with the one-liner. That would be a YouTube short or a community post. So check that out. And let's see what happens next in Florida versus Donna Sue Adelson. And mostly, can we get to the sentencing? We've already seen the victim impact statements. We already know she's going to be LWOP'd. So can we get there, please, soon? All right. See you all again very soon. In the meantime, stay safe. And remember that murder is not a way to solve problems. Okay, bye.
Before you publish that, Mrs. Adelson, do you need your headphones or your amplifier to hear the evidence clearly?
You need that amplifier, Donna? You forgot? Whoops, she forgot.
You may continue. We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.